upon resolution passed by a two-thirds majority of all members of National Legislative Assembly, provided in the provision of Article 104, Clause 2 of the Constitution of South Sudan, read together with the provision there. The sitting here is wasting of resources. There. The sitting here is wasting of resources and time. That beyond his jurisdiction, for him, in the provision of Section 16(4) of the conduct of our Criminal Code of Procedure, the only power of our President of the Supreme Court is only to constitute or to establish a special court for trial of juvenile offenders. These are not juvenile. To form High Court to preside, convince or preside, the special court to be presided over by the High Court or any senior justice, which is not the case here in the case of the first Vice President. And number three, a High Court judge may convince a special court. This is not relevant. It is irrelevant. So, which is stipulate that the President of the Supreme Court may, by order, constitute a special court for the trial of any accused under chapters 4, chapter 5 and 7 inclusive of the Penal Code. Number two, lack of a resolution passed by two-thirds majority members of all members of the Transitional National Legislative Assembly as provided in Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulations 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021. Therefore, the arrests and detentions of the first accused, His Excellency Dr Riak Machar Teny and his brothers, were carried out without lifting the immunity, rendering this proceeding unconstitutional, unlawful, illegal, and void ab initio. The right to be tried before a competent court, independent and impartial tribunal, is guaranteed under both international treaties ratified by the Republic of South Sudan and the Bill of Rights in Part 2. Bill of Rights is here in Part 2 of our beautiful Constitution, from Article 9 through Article 34 of our Constitution. It is about the Bill of Rights, it is about human rights, it is about the due process of the law, it is about the crack of the whip. Number three, relief sought. Wherefore, His Excellency Dr Riak Machar Teny and the 7 accused persons respectively pray this Honorable Special Court to order in their favor as follows. Number one, order this Special Court lacks of jurisdiction and competence to try this matter, and therefore null and void ab initio, pursuant to the absence of fulfillment of the requirements stipulated in the provision of Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature Assembly Conduct of Business 2013 as amended 2021. Number two, order the immediate discharge, release, and go home of His Excellency Dr Riak Machar Teny and his brothers from this court, and let them go home from today. Let them go home and have the business to do their job. Order the immediate discharge of His Excellency Dr Riak Machar Teny, the first Vice President of the Republic of South Sudan, and the 7 accused persons for being arrested and detained unconstitutionally. Number three, Your Lordship, any other relief this Honorable Special Court deemed fit, respectively submitted, date today, 22nd day of September Defense Advocate, Advocate Dr. Gary Raymond Lege Lobate, the lead advocate. Number 2, Advocate Kurlu Alkur, member. Number 3, Advocate Deng John Deng, member. Number 4, Warnyang Kir Warnyang, member. And finally, Advocate Anis Tombe Agustino, member. All, thank you so much. Thank you, my lordship.
After hearing the application of the defense, now we would like to give chance to the prosecution to reply.
My Lord, allow us to reply to our colleague, Dr. Gary, for what he has raised of his objection. This will be represented by one of the panel advocates.
Your reply be in writing or verbally?
We will make it because my lord will give an oral reply and we'll give you a snapshot of our reply.
And then you...
Yes, we'll give you a snapshot
and then
in writing.
Okay.
Yes. May it please this court, my lord justices of the special court. I will go slow so that we're able to record our submission in reply to the original objection raised by the defense team. My Lord Justice of the Special Court, I will start with ground number 1 of the legal objection.
My lordship, we object to these oral submissions. We are making history. Your lordship, we object these oral submissions. We are making history. The Republic of South Sudan is making history. We need all things to be in written form so that we put in record for this country. 2, we object the appearance of the private advocate because, as we have heard from our colleague from the security, the complainant, the appearance of any private advocate there is inconsistent with the provision of Article 133 of our constitutions of Republic of South Sudan, which shoulder all this responsibility under the Minister of Justice. Not any person else. Let me read you. Article 133, clause. Article 133, clause 3. Yes. Which is part 8 of our constitution. The public attorney and legal advisor shall be under the National Minister of Justice and Constitutional Affairs. Clause 3. Public attorneys and legal advisors shall advise all. No. The Minister of Justice shall be the chief legislative. The Minister of Justice shall be the chief legal advisor and the prosecuting authority at all levels of government and shall perform such other functions of legal nature as may be prescribed by law Number 3, public attorneys and legal advisors shall advise all levels of government, represent them in public prosecution, litigation, education, and conduct free trial proceeding. They shall recommend reform, strive to protect public and private rights, advise on legal issues, and shall render legal aid. This is a constitutional requirement. It is mandatory. It is peremptory. If we are not in a state of emergency, there is no any state of emergency which allow private lawyers to come. They are all there and they are competent to do the job, not anyone who is private. That is why we are here. Therefore, I call upon this honorable court to send them out to sit outside there with our brothers who are sitting there. And because to appear in this honorable court is a constitutional right, we don't object on that. They can move from here and sit with our brothers and sisters who are outside there. Thank you, my lord.
Okay. Let us separate between two things. You see, you are now like raising another point of objection, which is, in our view, will be a separate point. As for the reply, we think, as they told us, that they will provide a written reply, and now he's giving us the summary of that reply. Please continue.
Thank you. Thank you, my lord. I would proceed to provide our response to the defense objection. My Lord Justice, the first ground of legal objection is on the supremacy of the revitalized agreement on the resolution of conflict in South Sudan, 2018. It is the argument that the revitalized agreement shall take precedence over any national legislation, any existing agreement to the contrary, and in the event that the provisions of a national legislation or previous agreement conflict with the terms of this agreement, the provisions of this agreement shall prevail. My lord, this argument finds no basis in law. First, there is no conflict between the revitalized agreement and the law, so as to invoke it. In terms of competence of this court to try the first vice president, it is a prosecution argument that this court is competent to try the first vice president. My Lord Presiding Justice and Justice of the Special Court, Article 123E establishes the structure and hierarchy of a judiciary. And under E, it empowers that there shall be established other courts and tribunals as deemed necessary to be established in accordance with the provision of the Constitution and other law. This provision of the Constitution is reiterated, my Lord Justices, in Section 7F of the Judiciary Act 2008. As to the rules that shall apply to such other court as shall be established, my Lord Justices, Section 9 of the Judiciary Act provides for the same. In terms of paneling of these special courts, my Lord Justice, Article 126(3) of the Transitional Constitution 2011 as amended provides for paneling of special courts, that in case of criminal or civil matters, there shall be panels of 3, And when they sit as a constitutional panel, there shall be at least 9 justices, where the Chief Justice shall be presiding. The same provision is reiterated in Section 11.3 of the Judiciary Act. It is based on this narrative and sequence of law, my Lord Justices of the Special Court,